DK Basu v. State of West Bengal. This video explores the landmark judgment of DK Basu v. State of West Bengal, a significant legal precedent that has had a profound impact on upholding civil liberties and human rights in India. The case is a shining example of judicial activism, where the Supreme Court intervened to ensure that the state does not abuse its power and that citizens' rights are protected. The verdict led to major reforms in the criminal procedure, emphasizing the importance of due process and police accountability. It is a powerful reminder that the judiciary plays a crucial role in safeguarding the rights of citizens and promoting public interest. The case has been a benchmark for judicial review, setting a high standard for law enforcement agencies to follow. This video delves into the details of the case, its implications, and its significance in the context of constitutional law and India's justice system. Hi, I am Advocate Dr. Saurabh Kapoor, bringing you a video on this fascinating topic like this. But before you start watching this video, I request you to kindly like, subscribe and hit the bell icon to my YouTube channel to view videos like this more. Please leave a comment below telling your thought and idea about this video and future videos you want. Kindly share this video with your friends, family and social groups to spread this knowledge. Join me as I dive into the landmark judgment from 1996 that transformed India's justice system and see if I can uncover its impact in today's world. DK Basu v. State of West Bengal is a landmark judgment in Indian legal history that has had a profound impact on human rights and police accountability. This case is a testament to the power of the judiciary in upholding the rule of law and protecting the rights of citizens. In this video, we'll delve into the details of this significant case and explore its far-reaching consequences. So, let's get started. Introduction. When a perpetrator of crime is caught, the foremost thing that the legal justice system demands is that such a person be kept in the custody of the police, so that he can be brought to trial. This is a common way to address criminals worldwide, but it needs to be kept in mind that a criminal is also a human being. Indeed, some rights of a person who has committed an offense are taken away, but even then, the Constitution of India does not allow the reduction of a person from his humanity. This means that one of the most important rights in our Constitution, the right to life and liberty, enshrined under Article 21, cannot be taken away, that too without the person receiving justice. The atrocities committed on people who are caught by the police are nothing new, even though this behavior is absolutely wrong, but the administration does not pay heed to it. However, if a person loses his life because of such atrocities, it raises a lot of concerns. The duty of police is to prevent the offender from committing any further acts, not to torture him on the account of the crime he committed. When police take up the role of the justice system, that too in an unauthorized manner, the mechanism of justice breaks down. When a person dies in the custody of the police, it is referred to as a custodial death. And they have been on the rise in India. However, many attempts have been made in order to realize the situation of custodial deaths and to bring an end to them. One instance was the Supreme Court case of DK Basu v. State of West Bengal. Facts of DK Basu v. State of West Bengal case. Keeping in view the staggering rise of custodial deaths in India, a letter was presented to the then Chief Justice of India, by Mr. Dilip Kumar Basu, who was the executive chairman of a non-political organization, Legal Aid Services, in West Bengal. The letter, dated August 26, 1986, referred to certain articles in a newspaper, namely the Telegraph newspaper, mentioning custodial deaths. Mr. Basu requested that the letter be considered as a writ petition under public interest litigation. While the letter was being reviewed, another person stepped into the frame with a letter, Mr. Ashok Kumar Johri, who reiterated the matter by stating in his letter the death of one Mahesh Bahari, from Pilkhana, Aligarh, Uttar Pradesh, as being a custodial death. This letter, along with the letter from Mr. Basu, was treated as a writ petition by the Supreme Court of India. The court issued notices to all state governments regarding the same, as well as to the Law Commission of India requesting the formulation of appropriate measures to address the situation, within a period of 2 months. Subsequently, the Supreme Court received several affidavits by the state governments of Himachal Pradesh, West Bengal, Assam, Orissa, Haryana, Tamil Nadu, and Meghalaya. The Supreme Court also appointed Dr. A.M. Singhvi, who was the principal counsel on behalf of the state governments, as the amicus curiae to the court. Arguments presented in DK Basu v. State of West Bengal case. The issues raised in the writ petition revolved around the problem of custodial deaths and their increasing number, while simultaneously pinpointing that there was a need for specific guidelines to regulate police arrests and prevent arbitrary measures of the police. The arguments put forward by the side of the petitioner asserted that the mental agony and the torture that an arrested individual goes through in police custody is beyond imagination and that the same should be avoided at all costs. The respondents, on the other hand, contended that as per the respective states, the situation was fine. However, at that time, there were no guidelines that regulated custodial deaths, and therefore, the apex court, relying on certain judgments, ruled in favor of the petitioners. Judgment of D.K. Basu case. The Supreme Court relied on the judgment of Nilabati Bera v. State of Orissa, wherein it was held that torture of any form, or cruel and inhumane behavior towards arrested persons deprived them of their fundamental rights, especially Article 21, which is against the law of the country. A restriction on fundamental rights could only be imposed on the citizens in accordance with the provisions of the law. The same view was also observed in the case of Sunil Batra v. Delhi Administration. The Supreme Court also mentioned the case of Joginder Kumar v. State of Uttar Pradesh, and held that even though procedural requirements regarding arrests of criminals had already been laid down, it was found that police officers were making arrests without warrants. Simply because a police officer is allowed under law to arrest a person does not imply that he can arrest a person without reason, i.e., arrest should not be the routine. The Apex Court, in its judgment, issued the following guidelines that govern arrest and custody procedures required by the police to follow. 1. When the police are making an arrest, the details of all the police personnel involved in the arrest must be clear and accurate. Their name tags must bear correct and their particulars should be recorded in a register. 2. The police officer in charge of the arrest must prepare a memo of the arrest at the time, which shall be signed by at least one witness. This witness can either be a family member of the arrested person or could be a respected member of the locality from where the person is arrested. The memo will also contain the signature of the arrested as well as the date and time of the arrest. 3. When a person is arrested and put in custody by the police, he has a right to inform either his family member, or his friend or anyone known to him, of the arrest and of the place where he is put in custody. 4. The detained person is to be made aware of the above-mentioned right as soon as he is arrested. 5. If the family member, or friend, or the person known to the arrested lives outside the district or town, then the time and date as well as the place of custody of the arrested person must be made known to such person through legal aid organization of the district. The same should also be done by the concerned police station within 8 to 12 hours of the arrest. 6. The details of the arrest as well as of the arrested person must be entered in a diary at the place of arrest. The entry must also contain the details of the police officer under whose custody the detained person has been placed. 7. If the detained person requests, then he shall be examined of any injuries or marks on his body and the same must be recorded. This examination, called the inspection memo, must be signed by the arrested person along with the police officer in charge of the arrest, and a copy must be handed over to the detained person. 8. While in custody, the detainee shall be medically examined every 48 hours by a trained doctor, from a panel of doctors approved by the Director of Health Services of the concerned state. The director is required to prepare a panel of approved doctors for tehsils and districts. 9. The copies of all the documents should be sent to the magistrate of the area for his record. 10. During interrogation, the arrested person is allowed to meet his lawyer, provided that such meeting does not last throughout the interrogation. 11. Every district and state headquarters of police must have a police control room, and the details of the person arrested should be communicated by the police officer in charge of the arrest within 12 hours of the same. The said details must be pinned on a notice board in the control room. Overview of D.K. Basu v. State of West Bengal case. A person cannot be deprived of his life and personal liberty without the accordance of law. The right to life means something more than mere animal existence, and a person being deprived of the same violates the principle of rule of law. When a person is subjected to arbitrary procedures, it takes away the essence of Article 14 of the Constitution, which rests on the principle of equality, as opposed to arbitrariness. Adopting measures of third-degree torture by the police in order to extract confessions from accused persons is clearly violative of Article 20 of the Constitution. The state of Uttar Pradesh has the highest number of custodial deaths in India. The police in India treat the arrested persons as second-class citizens, and often attempt to take the law into their own hands. As per reports published by the National Crime Records Bureau of India, more than 50% of people who died while in custody were not even produced before a magistrate. When people die without even having access to justice, it questions the principles of the entire system of governance of the country. At present, custodial deaths have been reduced due to the stringent measures adopted by the government as well as the sound judgments delivered by the judiciary. However, still a large number of cases go unaccounted and every once in a while, a case of police brutality comes before us. There is still a long way to go, but conformity with the principles of the Constitution can definitely provide a swifter recourse to the issue of custodial deaths in India. What is the meaning of the term custodial death? Custodial death means death of a person while in custody. This term is used to refer to those arrested persons who die as a result of being confined in police custody without getting a chance to access justice. A person arrested by the police is only arrested on suspicion, and if such a person dies without getting a chance to prove himself innocent, it is referred to as custodial death. Who brought the issue of custodial deaths to the notice of the Supreme Court in 1986? It was the Executive Chairman of Legal Aid Services, West Bengal, a non-political organization, Mr. D.K. Basu, who brought the issue of custodial deaths to the Chief Justice of India, via a letter dated 26 August. The letter mentioned articles from a newspaper highlighting the problem of custodial deaths in India. The letter was treated as a writ petition in the Supreme Court of India. What was the judgment, in brief, of the Supreme Court in D.K. Basu v. State of West Bengal? The Supreme Court, in its judgment of D.K. Basu v. State of West Bengal, ruled that the custodial death of a person violates the basic fundamental rights, and the same is against the law. Custodial deaths are especially violative of Articles 14 and 21 of the Constitution, and the police should, in all manner, abstain from torturing a person in custody. The Supreme Court came out with certain guidelines governing arrest procedures of the police, making them stricter and more comprehensive so that they are adhered to. Air 1997 SC 610. Air 1993 SC 1960. 1980 Air 1579. 1994 CR. L. J. 1981. A. D. M. Jabalpur v. Shivkant Shukla, 1976 Air 1207. Khatri v. State of Bihar, 1981 SCR 408. The landmark case of D.K. Basu v. State of West Bengal is a significant judgment by the Supreme Court of India that laid down guidelines to protect the rights of individuals during arrest and detention. This case established safeguards against custodial torture and abuse by police officials. Below is a summary of the case. Facts of the case. D.K. Basu, a social activist, wrote a letter to the Chief Justice of India highlighting instances of custodial deaths and torture in police custody. The letter was treated as a writ petition under Article 32 of the Constitution, addressing the violation of fundamental rights under Articles 21 and 22. Key issues. 1. Whether custodial torture and deaths violate fundamental rights. 2. Whether guidelines are necessary to regulate police conduct during arrest and detention. Judgment. The Supreme Court, in its judgment, held that custodial violence and torture infringe on the fundamental rights guaranteed by the Constitution. The court issued a set of 11 guidelines to ensure transparency, accountability, and protection of detainees during arrest and detention. Key guidelines issued by the court. 1. Police identification. Police personnel carrying out the arrest must wear accurate, visible, and clear identification with their name and designation. 2. Arrest memo. An arrest memo must be prepared at the time of arrest, signed by the arrestee and at least one witness. 3. Notification of arrest. The person arrested must be informed of their right to have a friend, relative, or other person notified of their arrest. 4. Medical examination. The arrested person must undergo a medical examination at the time of arrest and every 48 hours during detention. 5. Access to lawyer. The arrestee must have the right to consult a lawyer during interrogation. 6. Entries in register. Details of the arrest, including time, place, and reasons, must be recorded in a police register. 7. Right to inform magistrate. The arrestee must be produced before a magistrate within 24 hours. 8. Copies to judicial authorities. Copies of all documents, including the arrest memo, must be sent to the magistrate. 9. Inspection of lockups. Periodic inspections of police lockups must be conducted by independent authorities. 10. Awareness of rights. The arrestee should be made aware of their rights under the law. 11. Accountability for violations. Any noncompliance with these guidelines would render the police officials liable for departmental action and contempt of court. Significance. This case is a cornerstone in protecting the dignity and rights of individuals during arrest and detention, reinforcing the principles of the rule of law. It also highlights the judiciary's role in curbing misuse of power by law enforcement agencies. Would you like a deeper analysis of any specific aspect of the case? The DK Basu case is a powerful reminder of the need for accountability within the police force. It highlights the darker side of custodial violence and the lack of accountability that often accompanies it. The case brought to light the systematic abuse of power by law enforcement agencies and the devastating consequences that follow. Indian legal history is replete with instances of police brutality and custodial deaths. Despite the gravity of these incidents, the perpetrators often went scot-free, enjoying impunity and a lack of accountability. It was against this backdrop that the DK Basu case was filed, seeking to bring about a drastic change in the way police officers operate in India. The case was a culmination of years of struggle by human rights activists, lawyers, and ordinary citizens who refused to accept the status quo. It was a testament to their perseverance and determination to bring about a positive change in the system. As we explore the case further, we'll see how it has contributed to a paradigm shift in the way police officers are held accountable for their actions. The DK Basu case was a watershed moment in Indian legal history, marking a significant turning point in the struggle for human rights and police accountability. It sent a powerful message to the police force, emphasizing the need for accountability and responsible behavior. As we navigate the complexities of this case, we'll see how it has left an indelible mark on the Indian justice system. Let's turn our attention to the central issue of custodial violence and the lack of accountability within the police force that prompted the case. Custodial violence is a serious violation of human rights, often leading to physical and mental trauma for the victims. It's a pervasive problem that has plagued the Indian police force for decades, with little or no accountability for the perpetrators. The lack of accountability is a major concern, as it creates a culture of impunity within the police force. When police officers are not held accountable for their actions, they feel empowered to continue their illegal activities, leading to a vicious cycle of violence and abuse of power. Custodial violence is often shrouded in secrecy, making it difficult to uncover the truth. In many cases, the victims are poor, marginalized, or vulnerable individuals who lack the resources to seek justice. This power imbalance between the police and the victims creates an environment conducive to abuse and exploitation. The police force is entrusted with the responsibility of protecting citizens, but when they themselves become perpetrators of violence, it erodes trust in the system. It's a serious issue that requires immediate attention and action, and the DK Basu case brought this issue to the forefront. Despite the gravity of the situation, there was a lack of political will to address the issue. The government and the police force seemed unwilling to take concrete steps to prevent custodial violence and ensure accountability. This lack of political will emboldened the perpetrators, leading to more instances of violence and abuse. The DK Basu case was filed in response to this culture of impunity and lack of accountability. The petition sought to highlight the systematic abuse of power by the police force and the devastating consequences that follow. It was a bold move that aimed to bring about a radical change in the way police officers operate in India. The case was filed by DK Basu, a social activist and lawyer, who was determined to bring about a positive change in the system. Basu was a crusader for human rights and had seen firsthand the devastating impact of custodial violence on victims and their families. Basu's petition was backed by numerous human rights organizations and citizens who shared his vision of a just and fair society. Together, they sought to create a system where police officers are held accountable for their actions, and victims are protected from abuse and violence. The case was a complex one, involving multiple parties and interests. The petitioners argued that custodial violence was a pervasive problem that required immediate attention and action. They sought to highlight the failure of the police force and the government in preventing such incidents and ensuring accountability. The state of West Bengal, on the other hand, argued that the petition was an overreach of the judiciary's powers and that the police force was capable of self-regulation. They claimed that the petition was an attempt to undermine the authority of the police and create chaos in the system. The legal arguments presented by both sides were robust and persuasive. The petitioners argued that the Constitution of India guarantees the right to life and dignity, which is violated when custodial violence occurs. They also cited numerous international treaties and conventions that India is a signatory to, emphasizing the need for accountability and responsible behavior. The state of West Bengal, on the other hand, argued that the police force is responsible for maintaining law and order, and that occasional incidents of violence are unavoidable. They claimed that the petitioners were seeking to micromanage the police force and create an atmosphere of mistrust between the police and the citizens. The Supreme Court's decision was a landmark moment in Indian legal history. The court delivered a unanimous verdict, establishing guidelines to prevent custodial torture and ensure accountability within the police force. The judgment was a testament to the judiciary's commitment to upholding human rights and the rule of law. The Supreme Court's guidelines were far-reaching, covering aspects such as arrest procedures, detention conditions, and investigation methods. The court emphasized the need for transparency, accountability, and human rights training for police officers. The judgment marked a significant shift in the way police officers operate in India. It sent a powerful message that the judiciary will no longer tolerate custodial violence and abuse of power. The guidelines have been instrumental in reducing instances of custodial violence and ensuring accountability within the police force. The impact of the judgment has been far-reaching, influencing police practices and human rights discourse in India. It has empowered victims of custodial violence to seek justice and has created a culture of accountability within the police force. The DK Basu case is a powerful reminder of the importance of human rights and the need for accountability within the police force. It has left an indelible mark on the Indian justice system, shaping the contours of police practices and human rights discourse. As we reflect on the significance of the DK Basu case, it's clear that it has been a game-changer in the struggle for human rights and police accountability. It has created a new narrative, emphasizing the need for responsible behavior and accountability within the police force. So, what are your thoughts on the DK Basu case? Share them with me in the comments below. And if you want to explore more significant legal cases, check out my video on another landmark judgment that transformed India's justice system.